Okay, well, if you're happy for me to attach the Form 12 to here take it out of there.
Certainly.
Okay, fine, well, that's fine then. I'll just attach this so it doesn't get taken away.
May I ask your name, please?
Sorry?
May I ask your name, please?
Denise Waybury.
Waybury?
Waybury.
Good to meet you, Denise. Waybury.
So was this the affidavit that you were seeking to file with your Form 12? This one here?
If that's the signed one,
It's
yes,
been
that's
signed.
correct. Yes,
Yeah.
that's
okay.
correct.
Fine.
I'm having a bit of trouble understanding exactly what has happened here, because it seems to me that within statutory power, which I suspect the registrar is exercising, there needs to be a logical explanation for each decision. That is, there must be intelligible justification based on evidence. Form 31 essentially asks me to refile exactly the same documents.
Well, you're effectively asking another judge to look at the documents.
But I'm a bit confused as to why the affidavit is here in the court, the grounds for the application is here in court, and the only thing Form 31 requires of me is to file grounds and affidavit, both of which are already available to the court for the court to make any decisions it needs to make.
Well, it's just an originating process to get the matter before another judge. So another judge will look at the decision of the first
I'm quite
judge.
confused. Firstly, before 6.07.2 of the rules are enlivened, it seems to me that 6.07.1 must be affected. There has been no explanation anywhere as to what clause of 6.071 has been affected.
Yeah, the
So
court doesn't give
I'm
that.
not able to understand what is happening here. I'm just not able to understand.
The registrar believed the matter was I can't remember the exact wording, but frivolous, vexatious, or an abusive process.
Well, that needs
so
to be.
she takes it to the judge, and the judge
I think
decides.
that needs to be communicated to me.
Well, the court
Else
doesn't.
I can't
it's
understand.
not the practice of the court
I can't
to give reasons.
but it's
in
a statutory power, which even if discretionary, must be exercised reasonably and must be based on logic. That is, the decision must be based in evidence, and there must be clear and intelligible justification.
Well, your remedy is to
for
put
that
in this
decision.
application.
The only
and
thing I'm
for it
seeing
to go.
here, I'm seeing this as an abuse of process and a vexatious
Well, you can,
and
you
vexatious
can make
conduct, in the sense that by requiring me to file an additional application, basically I could incur cost where there is no merit for the decision that has been taken, simply because any document that I've submitted via Form 41 was already available to this court.
Look, I don't make the rules. That's what the rules require you to do, and
I don't
I'm
know
sorry,
that-
I can't do
Yeah, but I don't know
anything.
that the rules require it, because the rule says if it appears to be vexatious, we should say so. If it's frivolous, we should say so. Or if it's an abuse of process, we should say so.
Well, the rules don't require that. The rules just require the registrar to form that view, take the matter
Yes,
to a
form
judge.
that view on the basis of evidence. It has to be logical. So
well,
it must be based in evidence, and it must be understandable.
Well, what are
And
you suggesting should happen now then?
I am suggesting that what has happened previously, when on 5th February these documents were sent back to me, it is an abuse of process, and that should be registered as an abuse of process, simply because
So what do you mean by registered? Who registered with whom? and
we
how?
should get that on file. I need Registrar Mussolino prohibited from handling my documents, because immediately there is, in my view, a deep sense of corruption which permeates the systems here. I am going up against a big company, and from what I've seen, decisions have been illogical, they've not been reasonable, rules have been used as an instrument of tyranny,
Well, you can put all that in
and
your
so on and so
application,
forth.
if that's what
And
you...
the court is to be governed by the rule of law. And the
Well, and
rule
you're
of
getting
law,
your right now to challenge the decision.
the
so
rule of
that's
law
what's happening.
supersedes everything else.
Yeah, I
The
don't
court needs to
disagree
be
with that.
impartial and independent,
court is.
and that should be reflected. That should be reflected in the actions of
Okay.
the court. So if you say to me, my documents are, for example, frivolous, you need to make the point that the claims I'm making are not supported by the evidence I've presented. Or if you say it's vexatious, you must be able to tell me
My role
that
at
it
the
lacks
moment
merit.
is to decide whether to take these documents. I've said I'll accept them, so I'll
Sure.
do that now. And there's not much
What's the
more
process?
can
I
do.
need to get a
Okay.
receipt and so on, because I'm really, really becoming quite distrustful of the processes.
Okay. Well, we'll deal with that. Now, this application for removal, you're trying to remove 4 matters from the federal court. Is that right?
That's correct.
Yeah. You'll need a separate application for each one.
This goes against the economy of the judicial system's
I'm sorry,
process.
but
It doesn't
that's
make any
just the way
sense.
it is, because they're
So
separate matters. This court has
no,
to
they're
deal
not
with
separate.
them
They're not
separately.
separate matters.
Well, they're separate in the federal court. They've got
I have
separate
no. They're
numbers.
being heard together.
Well,
From minute one when I filed them, I filed for these matters to be heard together. They form the basis of one justiciable controversy. It is against good judicial practice to try to fragment the proceedings so that we are chasing after multiple matters